Well, hello and welcome. You're watching Newscentre with me, Ashmit Kumar. Now, it's been a wait of 16 months. In August of 2023 is when the DPDP Act had been passed by the Parliament. 16 months later, here in January of 2025, we finally have the draft DPDP rules. There's a lot to unpack as far as these rules are concerned. Firstly, the government is insistent that this is a consent-based framework. Just a bit of trivia here. If you go through the draft rules, the third most used word, the third most used noun to be specific, is in fact consent. It's been used 56 times, and that is something that the government cites for establishing how it's seeking to build about a consent-based framework. So essentially, the companies will be reaching out to you, to me, as a user, asking for my consent for personal data. That, of course, is with respect to the consent-based framework, but therein lies the rub as well. Parental consent, a new framework being introduced here. In fact, some of the comments that came from highly placed officials within the ministry, they tell us that the Indian government, the Indian establishment is taking a qualitatively different approach, whereas not to ban social media or digital entities entirely for minors, for people who are not the age of 18, but qualitatively, the different approach being used here is that a mechanism of parental consent is being introduced. The parents will have to authorize access for their children. But the mechanics of this, how will it really work? How will that consent be sought? Is the mechanism and is the coding in the rules very clear? That is something that the industry appears to be struggling with and, in fact, has cited on multiple occasions. Then, of course, there's the question of the obligations that fall on these data fiduciaries. It's Ashwini Vaishnav, I spoke to him over the weekend. He was quite clear that he does not want a repeat of the European example. He wants a more simple playing field that does not stifle innovation. In fact, speaking of the minister, let's go across to him and let's listen to his comments heading into the draft DPDP rules.
If there is a bank account or any payment mechanism that a child is using, already there is a digital footprint available.
Sure.
So we have created a mechanism using virtual tokens and using the existing digital architecture. We should be able to have a seamless shift towards a digital compliance method in which we don't have to kind of, nobody should be required to go and say that, okay, this is my date of birth and this is, right? So all that stuff has been very well thought through and the industry has been consulted. Industry is on board on this. They believe that this structure that we have created here, where we use the existing digital architecture and we provide a verifiable parental consent framework using the existing digital architecture will work very well. And that's very important also because in today's world there is a big possibility of harm coming to children because of the exposure to a variety of platforms. So that's why it's very important that the benefits continue to accrue while the harms can be prevented.
Well, that was the Minister of Electronics and IT, Mr. Ashwini Vaishnav, in an exclusive conversation with CNBC-TV18. But let's move forward with unpacking this entire conversation around the DPDP rules. To take this discussion ahead, I'm now joined by Aparajita Bharti, the founding partner of the Quantum Hub, as well as Mayuran Palanisamy of Deloitte India. Thank you so much for joining us, to both of our panelists. Ms. Bharti, let me come to you first. The word that the government is clearly stressing on is that, look, we have a consent-based framework. There's no denying that. There is a consent-based mechanism that has been introduced. What will it look like in the weeks and months to come? Are we expecting a number of notifications that will give me an accept versus decline option on granting consent for personal use? How does this look in reality?
Hi, Ashmit. Thank you so much for inviting me, and a good start to the new year for all of us who have been waiting for the DPDP rules since 1.5 years now. I think, yes, the framework that we have in the DPDP Act is a consent-based mechanism. That is the only basis on which data can be processed for data principles. I think, however, the minister has also said that, there will be an implementation timeline of 2 years, because this is a big shift for the industry. Every MSME, every big company, every company of every size now is a data fiduciary, and they need to have systems in place to be able to implement these rules once they are notified. And these rules are also still under discussion. So I think we still have some time till we start seeing the effects of this in our daily life as users. But I think the industry has already started preparing for some of the simple things like consent, notice, etc. However, how they will exactly do will be on the basis of the rules that are finally notified, which are still under discussion, and we have time till 18th February to give feedback to the government. Speaking of rules, as you had mentioned, Ashmit, I think it's important that the industry gets an indication of how the government is thinking about implementing, and I think it's a two-way process. Because some of the things that the government has proposed now will be discussed by product teams internally on how the data flows will be, what will be the cost of compliance, where is it likely going to cause operational issues, and on that basis the feedback will be given to the government. And the government actually has been very open in listening to the industry, in engaging with the industry to understand operational challenges. And I think in all the meetings it has been very clear that innovation is paramount and it has to be balanced with concerns of privacy, and in that sense
Indeed,
we
in
have
fact,
taken a much balanced approach.
Indeed. In fact, that was a concern that even the minister had put across, that they do not want a repeat of the European example. India does not need stifling of innovation. But let's take this conversation across to Mr. Palanisamy as well, who's joining us. Mr. Palanisamy, the next question I want to ask you is with respect to one of the issues that was flagged here with respect to consent. We were talking about how this will look like going forward. Parental consent is already an issue where the industry is beginning to voice some concerns. There are some obvious loopholes that have been pointed out. For instance, there is no rule where it's been codified how the age that is being determined, that is being given by a child, will be verified. There is no mechanism for that as far as these rules are concerned. Then, of course, is the bigger challenge of implementing this mechanism of parental consent. What is the kind of conversations within the public policy rooms of companies as they look at parental consent and implementing that over the next 2 years?
Ashmit, hi. Very good evening. Prajita, good evening to you as well. And a very good evening to all the viewers of CNBC-TV18. Yeah, I think regarding the verifiable parental consent, right, Ashmit, this is in a fairly early stage. This was a little bit of surprise because we all knew that government will propose some sort of solution around it, but verifiable parental consent came as something fairly new, right? But as I think Minister also alluded in your conversation, right? I would say this is a very, very critical one, considering the safety of children, right? We all know that there is a fair amount of data being accessed and shared by children in online these days, right? So it is very, very important for us to kind of have a mechanism put in place for that. Coming to the side of the organizations, yes, we'll have to think about how do we make it practical, right? So this is where the verifiable tokenization, all those becomes a very critical one. I believe that whatever the existing digital infrastructure government has established, I believe that we would be leveraging on that largely, or the organization may be leveraging on that to kind of do this implementation, right? That's my initial thought, Ashmit.
Interesting. In fact, the comments that are coming out from the ministry is that they're taking a qualitatively different approach from what has been followed, for instance, in Australia, where there's a total ban on social media for minors. So they're taking a different approach. They're experimenting with something new, seeking the industry's feedback. Let's come back to another point that Ms. Bharti, you had raised with respect to the compliance burden. When we look at the compliances, there's a requirement of a data protection officer, the requirement for reasonable security measures that need to be deployed, a grievance redressal system. What does that do for a smaller entity, a smaller company, a startup with only about 15, 20 employees? How does this burden them? Or is this already a common industry practice that should not be an issue over the next 2 years?
Ashmit, I think this is a very good question. And actually, every law creates some kind of compliance burden on businesses. And of course, if you run a smaller business, then the cost is higher as compared to what your overall revenue is. And it's an added burden. So I think with the DPDPA also, there will be definitely some compliance burden that will be added on MSMEs. But I do think, and I want to go back to the parental consent point also. I think what will happen is that this law will lead to a lot of innovation as well on how to handle data and consent and parental consent. And we will see a lot of innovation in tech tools that will help businesses manage all these obligations that are there under the law. We are already seeing in other countries a lot of age estimation, age verification tools have been deployed. There are also accreditation systems which certify whether an age estimation tool is actually good or bad. So we do foresee that there will be a lot of innovation even in India, which will eventually then become just off the shelf, tools that you have to integrate with your website, with your app, etc. There will be some cost of it. Some cost is actually inevitable with every law. However, I do think that some of the things like retaining, records for 1 year under reasonable security measures, maybe they can be relooked at,
Sure.
because that leads to higher costs. But some costs are inevitable, and I do think that there will be a lot of innovation on how to make it easier for MSMEs in the coming years.
It's interesting you speak of innovation, Mr. Palanisamy. Let me come to you. One word that is being spoken of in context of innovation has been AI. I just want to understand a few loopholes here, if any, that, as far as these rules are concerned. There's an exemption that is provided for research companies. Is that exemption then available to a large entity, a global tech player such as a Google or a Meta or an Amazon to use the data, personal data, for training of AI models? Is that something that can be done under the current provisions?
So, Ashmit, I will not interpret it that way, right? It clearly says that it's for research, education, and statistics purposes, right? It doesn't mean that the large organizations who are largely leveraging on AI are exempted from this, right? But what is that most of the organizations who are embarking into the AI journey should keep in mind is that while we are talking about data protection regulation now, it's a matter of time we'll talk about AI regulations, right? So, I mean, what are the data which goes into the AI has to be taken care by the organization. That's a responsibility of any organization, right? So I think this is going to
Sure.
be a little bit of, I would say that in future is going to be a little bit of challenge for organizations if you're assuming that AI is being exempted from this particular regulation, right? If you ask me that, I'll
Sure.
not take that approach. I'll be a little more careful in terms of data which is going into AI, and obviously look for other regulations which is going to come in.
Sure. We're running out of time, Ms. Bharti. Let me come to you for a final comment. And this is on one key issue, which is exemption that has been provided to the government. All government entities that provide a subsidy, a benefit, a license or a permit are exempt from this act, are exempt from these rules, which basically means that a large chunk of public-facing government entities will not have to comply and need not bother with DPDP. Is that a concern for you going forward?
I think, Ashwin, that is a concern, because right to privacy is not just a right against the industry. It is also a right against the state itself. And I think the problem is not so much with the rules. The problem was with the act itself, where, the exemptions to the government were very wide. And the rules are just operationalizing those exemptions. So I think the problem is with the act itself, in that sense, that there are not too many safeguards in terms of government acting as a data fiduciary and following all the other rules that apply to other data fiduciaries as well. The second thing is that another power that has been given to the government is to call for information from data fiduciary or intermediary, which is in the rules itself, which also does not have too many safeguards. And there is no way that an entity can say that if you ask me this information, I don't want to produce this information, or please tell me the purpose for it, which I think also needs to be looked at, and some safeguards need to be built in that.
Right, Ms. Bharti, Mr. Palanisamy, thank you so much for joining us, giving us more color. It's only been 48 hours since we had the rules with us. So clearly a lot to unpack there. We'll, of course, continue these conversations going forward. With that, we're heading into a very short break. But coming up on the other side, we take stock of the data protection rules with the Electronics and IT Minister himself, Mr. Ashwini Vaishnaw, who has led the charge for the new rules on the other side. Stay tuned. Welcome back to News Centre. Now, Electronics and IT Minister Ashwini Vaishnav has said that the industry will have 2 years' time to comply with the Digital Data Protection Act and the rules. Now, speaking to me earlier over the weekend, the minister also said that India does not need data protection laws similar to Europe, which he says are stifling competition and innovation.
When this law was presented to the Parliament in November 2023, we had very clearly promised that it will be digital implementation. Sure. It will be completely digital by design. So in the last 1 year or so, despite the elections being there, general elections being there, we have worked very meticulously to create a completely digital portal, digital workflow, digital processes, so that when we finally start implementing this law, the entire data protection board will be fully digital by design first. Second, as you are aware, this is a very pragmatic approach towards data protection, and we have made sure that the balance between innovation and regulation, we have a huge innovation economy, right? Huge, large innovation startup ecosystem. And we have to make sure that citizens' rights are protected with full fervor, full confidence. So that's why we have created this structure where the innovation and regulation is properly balanced.
Okay. Let me ask a follow-up question then. When we talk about, you talk about balancing the rights as well as the obligations. You talked about a completely digital framework. I was going through the rules. Interesting bit that I think DPB will be the first board which will operate virtually with the chairperson and the members connecting virtually as well. So let's take this next logical question in terms of what does this do as far as obligations of data fiduciaries or companies collecting data is concerned? What does it mean for them? What are the obligations they're now looking at?
The obligations on the data fiduciaries are very well established as per the principles set out in the Honorable Supreme Court's judgment regarding consent, regarding purpose. All those obligations are properly set in the law, and the rules basically implement those. Like the law, the rules are also very simple in language. Very clear examples, illustrations are given everywhere. We have made sure that, as I said, in a very pragmatic way, we have made sure that we have not made everything very prescriptive. We have kept, because digital technology doesn't stand, right? It evolves every week. Every week there is a new thing which happens. So the law should be able to catch up with those developments. So that's why we have set the principles in the law and the rules, and the actual practice, the actual prescriptive, which whether to go to left, go to right, or how many steps to take, all that thing is part of the execution, and that's a very good framework which we have set. And we believe, we understand from whatever we have heard from our international counterparts and all, the compliance burden which happened in Europe and which killed the entire innovation ecosystem, which kind of damaged the innovation ecosystem in a very big way, that will not happen. Our innovation ecosystem will continue to grow with a proper legal framework.
Which is the next question that I had in mind. You make a reference to the compliance burden. We're looking at a situation where a company is required to have a data protection officer. There are requirements in terms of security requirements, reasonable security requirements that they're required to deploy, requirements with respect to storage and then processing of data. What does this do in terms of compliance, especially for some of the smaller entities that may, startups, innovation ecosystem that are collecting data?
Most of these things are today standard practice in the industry. For example, all the compliances, all the obligations that we have set, our interaction with the industry clearly indicates that people are fully prepared for implementing this. And we have given enough time, and we have interacted very closely with the industry in a very collaborative manner, so that people, there shouldn't be any disruption because of this law, right? So we have made sure that people are prepared, they come up to this level, and despite that we'll be giving a very reasonable time frame for people to give the final compliance.
One additional question, sir, one new aspect that we've seen has been from the perspective of data localization. There is now a provision in the rules which allows for the government to prescribe what kinds of data can travel overseas and which are required to be.
So there is no difference between the Act and the rules.
Sure.
The Act itself in the section 16 very clearly said that wherever required, see, we studied the best practices in the world, and we said wherever data is getting transferred to a trusted geography, where the other side is also taking the same precautions and the same safeguards, that we would have taken, right? And then we said that if there is a particular sector, that sector requires data localization. For example, even today, Reserve Bank of India requires that the payment data should be localized fully. So we maintain that structure, which is a very flexible structure, and we have, to prevent any sudden disruption by any particular sectoral regulator, we have created a committee mechanism so that there is a proper consultation before any sector wants to impose a set of restrictions.
So essentially there is that window for the regulatory mechanism of a specific sector to prescribe what forms of data are to be localized. You use the
Correct.
RBI example.
That is there in this rule in the Act, Section 16 already in the Act, and I think that's a very pragmatic way of looking at things rather than fully having a kind of one brush paints all kind of thing. It's a very pragmatic way of looking.
Just a couple more questions, sir. At the very outset, you began by telling us how this is a completely digital framework. The Data Protection Board, I think one interesting bit that falls was, of course, like I was pointing out, that this will operate entirely virtually. Chairman members will conduct meetings virtually. Just give us a sense, what does this translate into in terms of functioning of the DPB? How will it work? And where can the orders of the DPB be appealed? Is there an appellate tribunal framework?
That's a very clear framework prescribed of multiple levels so that the citizens' rights can be implemented without going through a very cumbersome legal process, right? So it will be a totally new way of working. We have had examples of digital implementation, various things in the last 10 years. Honorable Prime Minister has implemented Digital India as a part of every sector, right? So learning from all that has been implemented so far, this new digital by design, right from beginning, everything being digital, right from lodging a complaint to getting a hearing to making sure that the data fiduciaries give their response to the final order, then the appeal mechanism, everything is digital by design. And it's very well thought through. There is also a provision of voluntary undertaking, which means if somebody understands that it has caused a problem, it has violated the provisions of the law, that person, that firm, that company can go to the Data Protection Board and say that, okay, we made this mistake, so then it can be treated in a totally different way. So all those things are very well thought through.
One final question, sir. This one is with respect to government entities collecting data. I'll just ask a twofold question. Number one, as far as exemptions are concerned, exemptions are provided for the government services being provided, government subsidies, benefits, or licenses and permits being provided. Will that not cover a large chunk of the government functioning as a whole? Number one.
See, the government is also equally obligated to protect citizens' privacy.
Sure.
And most of the provisions of this Act, they are applicable to every data fiduciary, right? Regarding the, if a particular person has applied for one set of service, right? Isn't it proper that the person shouldn't be required to do the same set of submissions for another set of services, right? That's the ease of living,
Sure.
right? So that is the thought process when we say that if a government department wants to basically use the data which has been provided for one service and the citizen says that it's fine, I would like to access the other service also. So that's the thought process behind this.
Wonderful, sir. And what does this transition window look like? You said
About
there will
2
be
years.
generous time. There's a 2-year.
About 2 years, but most of the industry is already prepared for it.
Well, from one union minister to another, the government launched the second round of PLI scheme for the steel sector. Parikshit Luthra spoke to Nodal Minister H.D. Kumaraswamy. For more, take a look.
Second layer of 1.1 scheme, some lacuna, all those things, our ministry, what they have taken for the consideration, and some guidelines they have already changed in this 1.1 program in PLI scheme. In this actually, out of 6,000, around 6,000 crore, in 1.0 time actually what PLI incentive we actually decided to distribute, more than 4,000 crores still it is with the ministry in that PLI scheme, that amount is there. by involving by today's what we open the application, they can participate in this and they can utilize this PLI scheme to strengthen the
Any particular
the growth of the steel ministry.
So the focus will be on specialty steel and electrical steel. Is that correct?
No, that is the specialty steel and electrical steel. What the word is there, but up till now, that proper actually what is the background, nobody has explained now, up till now. But they are working out in this.
Well, with that, it's a wrap on this edition of News Centre. For more news and updates, keep watching CNBC TV 18.